colleagues, I think we can have this clause the way it is, okay? Because you see, what you're considering is that court is a neutral arbiter in the matter. You know, sometimes interfering with the works of court, trying to limit it, trying to, because like investigating narcotics, I mean, it's not easy. This is very, very complicated. This is a very, very complicated exercise. It's not a cup of tea. Okay? So, Honorable Chair,
Mr. Chairman, when you look at 33, a period of 30 days is actually provided. It's still ahead, but it takes care of the concerns that you can actually apply after 30 days. When a restraint order is issued, court will then entertain you.
Yeah, and it will listen to you, and at its discretion.
Yes.
Say, here you can, you can grant or you cannot grant. Okay. Yeah.
Mr. Chairman, your statement on the asset is very dangerous. When you say investigating drugs like narcotic takes many years, people will bring it that even the Speaker of Parliament said it takes long, and somebody will come and clamp your property and they say it takes many years when they're doing nothing.
Let me use the word it's complicated.
Maybe that.
Yes. Thank you. Honorable Chair, the proposal by the Minister that we retain the clause the way it is, then, yeah, you need to go on record. Yeah.
I concur with the Honorable Minister and beg that
Thank
we
you.
move on.
I put a question that clause 30 stands as part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Aye.
Clause 31.
Chair, clause 31.
Right, Honorable Chair. Clause 31 deals with offences in respect of restraint order. Clause 31 of the bill is amended by substituting for the words for not less than the words for a period not exceeding. Justification for this, Right Honorable Speaker and dear colleagues, is in compliance with Section 37 ahead of the Section 37 of the Interpretation Act to prescribe the maximum penalties that may be suffered by a person convicted under this act. I submit.
Okay. I put a Honourable Minister.
Amendments allowed.
Thank you. I put a question that clause 31 be amended as proposed. Those in favor say aye, to the contrary nay. Ayes have it.
Aye.
Clause 31 as amended.
I put a question that clause 31 as amended stands as part of the bill. Those in favor say aye, to the contrary nay. Ayes have
Aye.
it.
Clause 32.
I will request our IT administrator to mute everyone on Zoom, so that if you want to submit, you inform us that you want to submit, and then we allow you. Okay? But I want to appreciate the colleague who is very active. Yeah. Yes.
Clause 32.
Chair.
Thank you, Right Honorable Speaker. In the wisdom of the committee, having scrutinized the bill, they propose to this August House that we delete clause 32. Justification is that a restraint order only caveats any dealing in property but does not vitiate ownership. The purpose of the restraint order is to preserve the status quo. The property remains the property of the accused. 2. The proposal to transfer property affected by a restraint order to the official receiver has the effect of interfering in the proprietary interests of the owner of the property before the person is convicted of an offense. This goes beyond the effect of a restraint order. The provision is there misplaced and should only apply where court convicts a person of an offense and orders for forfeiture of the proceeds of crime to the official receiver. I submit.
Honourable Minister.
Justification sound. Amendment allowed.
Thank you. I put a question that clause 32 be amended as be deleted. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 33.
Chair.
Right, Honorable Chair, clause 33 deals with the exclusion of property, recognition of claims, and revocation of restraint order. Clause 33 is amended in subclause 4A by A, substituting for the word before the word after. B, substituting for the words complaint is made or information is. The words charge is preferred. The justification for this is for clarity to adopt a nomenclature used to refer to criminal complaints under the laws of Uganda, and two, to determine the duration of the expiry of the restraint order. I submit.
Honourable Minister.
Allowed.
Thank you. I put a question that clause 33 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 33 as amended.
I put a question that clause 33 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 34.
Chair.
Right, Honorable Chair, clause 34, there is substituted the following: where an application has been made to the court under section 23 for a restraint order, and the person against whom a restraint order is sought is charged with specific offenses, court may, on the application of the Attorney General or the respondent, stay the hearings of the application made under section 23 until a final decision is made in respect of the criminal charges. Justification for this is one, to remedy an ambiguity in clause 34, since currently the provision is not clear as to the application it is referring to. I submit.
Thank you. Chair, Honourable Minister.
Would you, Right Honourable Speaker and honourable members, be wise to qualify the length of the stay? Because it may go on forever, so I don't know.
So are we not wise enough?
You are, Right Honourable Speaker.
Yeah, he's making a humble proposal. And what would be your proposal, Honourable Minister? You know, when you go on the floor here, you propose. You don't throw a dice.
Right Honourable Speaker, still without trying to usurp the jurisdiction of court, yeah. I don't know whether if we use the word reasonable time. Or 6 months to be specific.
Yeah, because you see, a court has a period in which it will determine the matter. Now, once we start interfering with this, I think yeah. So, Kanya?
We have other legislation where we advise court on time limits. So many of them, the common ones, the Parliamentary Election Act, we propose time. Time is very important, Honourable Mr. Chairperson, because, for example, if you are the owner of Sheraton and then you have restraint order, and the restraint order is a result of maybe $1 million, and then the period is extends to create loss, and also to put pressure on the investigation institution to conduct investigation, conclude, and so that business can continue. Because Mr. Chairperson, as you know, as you said, it might be witch hunting and might affect other private business.
No, Honourable, this is stay of hearing of application.
Yes, so issues of 6 months is very important.
No, this is stay of hearing of application. The the one you've used of erections is making a final decision. Now this one, what if you're found guilty at the end? You know? So, colleagues, I put a question that clause 34, that clause 34 be amended as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 34 as amended.
I put a question that clause 34 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 35.
Chair.
Right Honorable Chair, clause 35 concerns the death of a person to whom the restraint order is made. In the wisdom of the committee, having scrutinized the bill, they propose this August House that we delete clause 35. Justification. Clause 35 proposes to continue proceedings against an accused person who dies before or after a restraint order is made, in contravention of clear and known principles of law, that criminal proceedings abate or terminate upon the death of the accused, as was laid out in the case of R versus Senyonga, 1993, and that citation is there. The death of an accused person should terminate the restraint proceedings or orders made since the accused person has not been found guilty of an offense by court to warrant the continued attachment of his or her property. I submit.
Yeah, you know, it's a principle, and again a very thin line, you know. Proceeds of suspected proceeds of crime, and for example, a crime like trade in cocaine that is in lots of monies, but again, a law is a law. Honourable Minister, are you having?
Thank you, Right Honourable Speaker. I would want to pray that we retain clause 35 because it is in respect of a restraint order made against the dead person, which passes on to the successor in title, and who can also apply for its revocation.
Yeah, because this is on property. Okay, this is on property, not the individual. We are pursuing that property. Yeah, so, Honourable Chair.
This bill remains a property of government. The responsibility of, and they are the implementers. I have absolutely no qualms in agreeing with him, but he should justify.
Mr. Chair.
Yes.
I wanted
Chair.
to hear from the minister why is, because the principle of law is well laid down, but why is this particular, retaining this contravenes the well laid principle of law? So I'd want to hear from the minister why we are coming up with something new contrary to the well laid out principles of law. If, however, I would want to hear from the minister.
Yeah, we can get other views, Honourable Minister, then you answer to one. Yes, Honourable Seungu.
Find out. It's unfortunate that Attorney General is not around. I am the owner of the property. I've died, but there's a case against me. I still have the presumption of innocence until I'm proved guilty. So if I'm dead, how would you proceed with my property when I'm not around? The principle is very clear, and I would wish the Attorney General to come in unless you stand over that clause.
Yeah, but Honourable Seungu, in law school, you were clearly taught that for every general rule there is an exception. So, can we try to dig into that exception? Honourable Aisha?
Thank you so much,
I'm going
Chair.
to get your views.
This clause takes care of two scenarios where an application is still being heard in court and the person dies before a conclusion is made. Is different from where actually restraint order is being granted. Where it's been granted, we should go up to this person's wealth because court concluded, well, that person is still alive. But where the person passes on and that person is not available to be able to make a case for himself is a different situation. So for me, I want to appeal to the House that we go for that time when actually execution is not being done, the person dies off. When execution is not being done, we should go for the wealth of this person. But if hearing is still on, then there's no person to go against.
Yeah, but you see, Honorable Aisha, a restraint order is not a final. A restraint order is temporary on your property so that you don't move it. A final decision has not been made. They have not determined that this is a proceed of crime. Okay? So, Honorable Jonathan, yes, I'm going to allow you, colleagues. I'm going to allow you.
Chair, I would like to agree with the minister,
Yeah.
and if you give me time, I'll cite that authority.
Yeah, sure.
There is an exception in the law, and I will cite that law, that the criminal proceedings can only terminate with the exception of property. Because the legal representative, whether you actually die or you are acquitted, once property has remained, it has to be dealt with in some way. So your legal representative should put a case before court on why that property should be lifted and given to him. So shortly I'm going to give you the
Sure.
reference here.
Sure. This is not like a crime against an individual of killing. Yeah, you say someone can take it over. It's the property. This is a suspected proceed of crime. So do we leave you to enjoy it because you died? Honorable Nanda, then Honorable Sarwani.
Mr. Chairman, I think Jonathan has done it well. Even if he hasn't, even if he's still looking for the case. Mr. Chairman, this one has two implications. A person, if he discovers that this property wants to go to his hands, he can kill a human being because he wants it. It's very dangerous if we put it in the law. Two, we're dealing with a property which is suspected of a crime. Now, the person who is suspected of a crime has died. But the one who wants that property must come and prove that the person who died never committed a what? A crime. So, Mr. Chairman, any property which is dealing with
No, in a criminal matter, the burden of proof is still
sorry,
on,
I want to do that.
huh?
That the person who owned the property until the state can prove that the person who died really dealt with drugs.
Thank you. Honorable Sarwani.
Right Honorable Speaker, even me, Right Honorable Chair, but still Speaker, even me, the paralegal, can clearly see that the presumption of innocence is always there before judgment. So there is no way, Right Honorable Speaker, would come up and put a law, because this is not the first law that we are making. There are other laws that are already standing on the same principle. There is no way we should pass a law as a house and say that they pursue my property when I have gone, much as, because how do you prove that it was the result of that crime or selling narcotic drugs? Because I've already died. So I strongly think that we should not go for property, because going for property means that, yes, honorable members, I want to implore you. Somebody has died when the trial is still going on. How do you prove? Because you are innocent until judgment is done in court and you're proved guilty, honorable members. So I want to implore you, honorable members, and Right Honorable Chair, that we accept and we don't go for property.
Now, you got information? You got the information?
Yes, but Chair, I think we are mixing it. The restraint order is not a criminal proceedings. It has to be clear. This is a civil matter.
Yeah.
So the question on the principles that apply to criminal law does not even arise.
Yeah.
And that is why I heard the procedure is by notice of motion and etc.
No,
So we are dealing with civil
Honorable Jonathan,
procedure.
you've made it very easy. That's why I was still... No, that settles it. That settles it. Because the proposed amendment is for criminal procedure. Under civil, property can still be pursued. And movement of property is a civil matter on all this. So, Honorable Chivumbi, you wanted to add on?
Honorable Speaker, I think we are dealing with the dicey matter. You do not want to take in law they call it the literal interpretation being given by our colleagues. in a way you are saying, first of all, this restraint order is interim for state to take steps to prove. So by the time it is existing, they have not yet proved that this property is a result of illicit drugs or illicit money. But then in the way you are saying that the administrator of my property, when I've died, should also somehow inherit my crime, because he has go to court and prove that this property was not a result of, and I'm not around. I find it very difficult for a parliament to enact such a law. It's very tricky. Right, Honorable Speaker, I would beg your indulgence and the minister to agree. Information.
Mr. Chairman, thank you, Honorable Member, for giving way. Let us be open, Honorable Minister. You know that people are smuggling goods in Uganda, and the smugglers are very rich. They have been smuggling cigarettes, and they become rich. But after getting them, do you go to their property? Cross-border, you go to cross-border? Trade. But you know, even there's a member you normally call here, Honorable from Busia. So, Mr. Chairman, I think we have to be very careful on that. These people, smuggling has been here from Amin, he brought Bobo Asos here in coffee, but property was not attached to the people.
Colleagues, all issues we are fearing for are covered for under subsection 2. Let us not only focus let us not focus on subsection 1 without looking at subsection 2, which covers all these fears and where court is having all this power. I put a question that clause 35 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 36.
I put a question that clause 36 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. Ayes have it.
Clause 37.
Chair.
Honorable Chair, clause 37 deals with forfeiture of property. In the wisdom of the committee, they had recommended that we delete clause 37, and justification for this is that clause 37 is redundant since it is a duplication of clauses 41 and 42 of the bill. The provision clause 37 has been incorporated in clause 42, which we shall read, and 2, the provision unfairly attaches all property of the person, present and future, irrespective of whether the properties were proceeds of crime or not. I submit.
Honourable Minister.
I agree for the deletion.
Thank you. I put a question that clause 37 be deleted. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 38.
Chair.
Right, Honorable Chair, clause 38 deals with certain liabilities to the forfeited property. Clause 38 is amended by substituting the head note for certain liabilities to the forfeited property. B, by substituting for the words section 37 shall not, words the restraint order shall not affect. And the justification is consequential amendment as a result of deleting 37.
Consequential amendments, Honorable Chair, are dealt with at the end. Okay? So I don't know whether now I start going into consequential amendments. Okay? But since it is straight one, I think we can sort it. We go with it. Because we deleted 37.
Yeah, but Chair, legislation must flow. The only problem I have is that it is now a parachuting from nowhere, that specific one. Now that you recognize that you are dealing with forfeiture ahead, I would rather suggest that that specific provision be moved after until we have dealt with 30, I think
42.
Yeah, up to 42.
Yeah.
and then you bring that.
So
because
let's do consequential amendments
Yeah.
at the end.
Yes.
Okay?
Yes.
No, all consequential amendments. Okay? We shall move. Then after 46, we are very sure. We capture it, you note it down, okay? And then once we finish, we shall come back to consequential amendments so that we flow easily. Okay. So let's deal with it, okay? Let's deal with it, and then the clerk will take note of it. The moment we go up to 46 and we've agreed, then we shall maintain it. If we don't, as a consequence, we shall delete it, okay? I put a question that clause 38 be amended as proposed. Those in favor say and to the contrary nay. Ayes have it.
Clause 38 as amended.
I put a question that clause 38 as amended stands part of the bill. Those in favor say and to the contrary nay. The ayes have it.
Clause 39.
Chair.
Right Honorable Chair, clause 39, provision for payment of money owed. Clause 39 is amended in subclause 1 by substituting for the word section 38 the word section 42. Justification: consequential amendment as forfeiture is provided by clause 42. I submit.
But I don't know why your clerk didn't help you on all this so that we have consequential amendments later. But let's do like the way we've done the other one. We shall take note. In case we don't agree, we shall come back to it. I put a question that, yes, Honorable Nandara.
Mr. Chairman, I just want the chair of the committee to assist me. If you are paying this money, do you pay to the official receiver or you pay to government of Uganda as a consolidated fund? Because here what I'm seeing is say to the receiver, forfeit the receiver. Yet the money should be paid directly to the consolidated fund.
Honorable Chair.
Money that is paid as a result of court proceedings is what you mean? Because then it's paid to, it's according to the procedure.
Mr. Chairman, because the money you are getting is for the state, and the state has only one account, which is the consolidated what? Fund. The moment you put more hands as a court or whatever, this money may never even reach there. It may be diverted. So, Mr. Chairman, wouldn't it be better for us to say that all the money which is owed is paid directly to the consolidated fund to avoid?
Honorable Minister, why did you consider receiver? But colleagues, do we even need to say where it should be paid? Isn't it? Because government laws, what if you change in future and you say this should be paid here? You know? Yeah. Yes. Well, what if you say it's paid to the state? Isn't it?
No, Chair.
Isn't it a standard where the money
Chair.
is paid to the state goes?
Chair, we currently have a problem, if you look at Auditor General's report, where certain monies of civil nature and criminal are paid to account in court and other government institutions because they want to do reconciliation. And by the end of the day, some of the accounting officers mix this fund, and the government does not receive all what is due. So it's just proper that the law is very clear that this money goes to consolidated fund account.
Yes.
Chair, under clause 32, we deleted the official receiver. So there is no actually provision for appointment of the official receiver. So in this case, consequentially, where we have the official receiver, we can replace by state at the disposal of the state, or whichever is applicable.
Honorable Minister, you want to say something?
Right, Honorable Speaker, Since property can't be under the consolidated fund, can't we retain official receiver?
Yes, clarification on your Aisha?
Chair, I see a rehabilitation fund on 54. And it continues to say that proceeds that come out of forfeiture, they will go to that fund. I don't know why they have not even already allocated it to the fund.
No, first of all, have we agreed to that fund?
But the proposal, because they say a portion of the property forfeited to the state under Part 4 as may be assigned to the fund by the minister responsible for finance.
Yes, but we've not yet agreed to establishment of the fund. Okay? But anyway, let's go with the proposal of consolidated fund to make it very easy. Because we have, I'm seeing money is going to government anyway. Okay, so you will, if we find any problem, the technical bench will advise and we can recommit that clause. Okay? Honorable, you had already submitted, you wanted a consolidated fund, and we are agreeing with it. I put a question that clause 39 be amended as proposed. Those in favor say aye, to the contrary nay. Ayes have it.
Clause 39 as amended.
I put a question that clause 39 as amended stand as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 40.
Chair.
Honorable Chair, Clause 40 is a claim by a person who commits a specified offense. Clause 40 is amended A in subclause 1 in paragraph A by inserting immediately after the word succession the words or that the property is held by him or her in trust for the benefit of another person. 2. In paragraph B, by substituting for the words relations, the words any person. In subclause 2, by substituting for the words section 37, the words section 42. C, by deleting subclause 3. Justification for this, Right Honorable Chair and Honorable colleagues, is consequential amendment arising from deletion of clause 37. 2, to include property held in trust among properties that can be freed from forfeiture. 3, to expand the list of persons who can gift property. 4, the deletion of subclause 3 is a consequential amendment arising from the amendment of subclause 1B. I submit.
Yes, Honorable Seungu.
Mr. Chairman, I pray that we make a small amendment on the notice in newspaper of wide circulation.
No, Honorable, in Parliament, we don't deal with small things.
Mr. Chairman.
Even a comma is big.
Yes, I'm saying let it be of notice in a newspaper of wide circulation. Not a newspaper alone.
Yes, I agree with you. Huh? Yeah, and the original text had it. So wide saturation is very important. Okay, Honorable Minister. Honorable Guzuri first, then Honorable Minister.
Yeah, Chair, I think while processing a similar law, we had such a challenge where we only have a mention of newspaper. I think the world is going digital, so it would be good that we address ourselves to media of wide circulation. It can be radio, it can be on internet, but to limit it to newspaper only would, I think, be counterproductive.
No, one will even demand TikTok, another on social media. No, you must have a limit. No, you must have a limit. Honorable Minister? Yes. Yeah, you must have a limit.
Amendments agreed to.
Thank you. I now put a question that clause 40 be amended as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 40 as amended.
I put a question that clause 40 as amended stand as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 41.
Chair.
Right Honorable Chair, clause 41 deals with procedure in respect of forfeiture. For clause 41, there is substituted the following. Procedure in respect of forfeiture. 1. Where a person is convicted of a specified offense under this Act, the Attorney General may, after conviction, apply to the High Court for an order to forfeit to the state any property owned by the convicted person that is ascertained to be proceeds of a crime under this Act. 2. Notwithstanding subsection 1, the Attorney General may apply to the High Court for an order to forfeit to the state any property held by any person that is ascertained to be proceeds of a crime committed by a convicted person under this Act. 3. The application referred to in subsection 1 and 2 shall contain a description of the property in respect of which the forfeiture order is sought. 4. Court shall, before making an order to forfeit the property of a convicted person, comply with rules of natural justice. Justification for this, Right Honorable Chair and Honorable colleagues, is 1. To streamline the process for applying forfeiture orders. 2. The amendment proposed in subclause 2 is for clarity and to harmonize the provision with clause 42, which duplicates the notices that are issued by the High Court. I submit.
Yes, Honorable Ekanya.
Thank you very much, Chair. I want to seek clarification from the chairperson, because I've been reading, we are talking about property, but when we are talking about proceeds of crime, we need to look at value. I know if you pollute, one tomato can rot other tomato, but you have brought it very clear here, applying the rules of natural justice. That A, use proceeds of crime to complete construction of a property, and that property could be $1 million. And yet the proceeds of crime that has been investigated and established is just $100,000. How do we take care of, have you taken care of that when you talk about applying the rules of natural justice?
But colleagues, really, we are even going to educate on the rules of natural justice. This is redundant. This is provided for in court proceedings. So the proposal under 4 is even redundant here. Yeah, let's do a clean bill. Yes.
I don't want to agree with someone's property who has been dealing in narcotics. Once you get him, you are taking him for reprimand. And when you take him for sentencing, you are shaping him. Now, this person is not corrupt, but he has been committing an offense of selling narcotics. Now, when you go to his properties and you attach them as government, it's not proper. That's not there. I don't know where it is in the world. You could guide us, Mr. Chairman. Otherwise, you are going to charge him in court. You know he got property worth 3 billion and is very rich, but he's going to be sentenced for 20 years in prison. Then how do you come and take property? You can't.
Thank you.
Let us look at that very carefully, Mr. Chairman. Then how is he corrupt? Because under the Anti-Corruption Act, it's clear you got assets out of government funds you stole. But this man was dealing in smuggling, selling narcotics. But he was caught. And when you take him to prison, you are shaping him. For 20 years, he's going to be under arrest. So what he has got, the proceeds, how will you manage to know that he got them from narcotics? Because I can get 5 billion from narcotics and I use them to invest in another deal somewhere else. Okay. Then how would you attach that property?
Thank you. But
it can't be.
But Honorable Sewungu, if you're saying property of the corrupt should be sold, okay? What about property from cocaine? As if you don't know the impact. Usually how they do their impact on the community. I think the debate should be how you use proceeds, okay? How government would use money gotten out of taking of that property, confiscation of the property.
Respond. Mr. Chairman, under the Anti-Corruption Act, it is clear Sewungu was a civil servant. He stole money from government. And after getting his assets, they are attached by government. Because he got these proceeds all wealth through corruption. But he's a gentleman whom we have just discovered that is selling narcotics. He's not corrupt. Once you get him, you are charging him under the law, but not the property. Because you are going to sentence him. And he has people to live with at home. What if he put all these assets under the names of his children?
Honorable Minister,
how will you get there?
Then Honorable Kanusha.
I think what Honorable Sewungu is trying to do is to reframe the objects of the bill, because he said the following are what we want to achieve through this bill. Among others, the proceeds of sale of narcotic drugs and psychotropic substances. So if we don't go for them, what else should we?
Colleagues, narcotics destroy society. So if you want to destroy society, and then for you remain in your comfort and your family, they can come see you in Rizira in a Benz. They can buy you food of Serena and bring it to you because you're enjoying proceeds of crime. No. Honorable Kanusha?
Right, Honorable Speaker, I think you've said it properly, but I think just to respond to Honorable Sewungu, that also some laws provide that you can have both. You can be sentenced and your property can also be attached. And we have seen people who actually commit those crimes and say, for as long as my family, I have left my family with 10 billion, I can go and sleep in Luzira. So for me, I think that we might have to consider either or even both, so that the discretion of the court can decide that if you have been selling, you can, the court can decide to attach your property and again sentence you for a period of time. But I don't think we should leave property for people who have committed crimes for their families to enjoy.
Thank you. Now, colleagues, when we are on committee stage and the colleague is submitting, please hold your peace for that time. This is a very sensitive stage. Okay? When someone finishes, then you can stand up. I'll give you a chance. Honorable Aisha.
Thank you,
Honorable Santa.
Chair. I don't know, Chair, whether you're proceeding well, because we actually handled that matter yesterday. Under Clause 1, all the justification that is being given here was given, and the House agreed in unison that over and above the criminal charges, there should be forfeiture to the state. That is under Clause 1. If Honorable Sewungu wishes, he can recommit this Clause 1, and then we see what to do. It was handled yesterday.
Thank you. Honorable Santa.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I'm not sure whether Honorable Sewungu was here yesterday, because we passed this and agreed as a House yesterday, and he's trying to use this chance to recommit in a wrong way. Mr. Chairman, this is a very big issue that we are handling as a country, with a very detrimental impact to our children. And for me, we should not leave people to enjoy the proceeds of this crime or leave it to their relatives and encourage them. Then what shall we be doing? It will be self-defeating, Mr. Chairman.
Thank you. Honorable Komakech.
Thank you, Chair. Chair, the money that the dealer has gotten is actually unlawful money. He deals in narcotics that is unlawful to get the money. Meaning, it's not about prisoning him only. It's where did he get the money from? If the money is illegal, there's another aspect I would want to interest this House with. Dealing in drugs entails cartels. It's not about one man, as if it's selling of a shop. No, it's either a father and a group of more others. I would think this law taking away the money from the dealer would also limit the cartel members from participating in the trade.
No, I want to give others a chance, Doctor.
Thank you very much, Right Honorable Chair. Right Honorable Chair, you have already said that narcotics destroy society. And we know that there's a lot of money in drugs. And when people who deal in drugs, they get this money, they'll be able to invest it and acquire assets. I think the spirit of this law is actually to prevent dealing in drugs in the country. And therefore, I think we want to put measures which are deterrent enough so that people not get involved in in dealing drugs. And one of that is by taking the property. I think that's my take. Thank you.
Thank you very much, Right Honorable Speaker. I think when we are making the law, we make the law to make people aware of it, to not to do the bad acts. So at the end of the day, when we bend the law to favor people in another way of doing bad acts, then doesn't help. To me, I think the best thing is, if somebody has stolen the money, for example, and it is evidence that a person has gotten, took the money from the government, for example, the person can be convicted and the property can also be attached. That makes a person to be very much aware that if I do this, this is going to happen. The Honorable has just mentioned it. This is very true. There are people who say, I'd rather steal 10 billion, I go to prison, my family enjoys. So at the end of the day, what does the law, how has the law helped us? So to me, let the property also be attached. Thank you.
I had allowed Dr. Pio.
Thank you, Right Honourable Speaker. I believe that the spirit behind this law is that you're taking the person to prison to rehabilitate them. But there are lives that you've destroyed that need to be rehabilitated. And there's a financing cost for that. And we've said that this money goes into the consolidated fund. So it is financing the rehabilitation of the lives that have been destroyed. But secondly, we've known of cases where people have gone to prison, but they're still operating their businesses in prison. We've seen cartels continue to operate because the person still has the funds in the account. So the intention is to cut off the whole cycle of the cartels itself. Thank you.
I put a question that Nambeshe.
Thank you, Mr. Chairman. Mr. Chairman, I realize that in this clause, we are likely to offend the doctrine of innocence. Because if attachment of property is left to the convicted person to prove that this particular property was lawfully acquired, isn't that shifting the burden of proof to the accused, which offends the doctrine of innocence?
Honorable Jonathan Odu.
Yes, Chair, my submission is actually different. First, I wanted to persuade the House to reject this amendment and go by the original text. If you read the original text, it's more comprehensive. After a person has been convicted, it provides a procedure where even other people, because after the conviction, the property that has been cited and any other property can actually be attached. The procedure laid in the original text, including publishing in newspaper, wide circulation, the property that now the state is interested, the Attorney General is going to take over. It gives any other person with a claim opportunity to come. So if the chair is pleased and the minister is paying attention, we are better off with the original clause other than substituting for what has been proposed.
Which limits to the Attorney General. Because you see, if that cocaine destroyed my family, I've been seeing it everywhere in America and all that Me Too movement, people coming up and making claims, some under public interest litigation. You know? Honorable Chair?
I agree with the proposed amendment.
I put a question that clause 41 stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 42.
Chair.
Right Honorable Chair, clause 42 deals with forfeiture order. Clause 42 is amended A by substituting for subclause 1 the following. 1. At the conclusion of the proceedings under section 41, the court may, where satisfied that the property is a proceed of a crime under this act, make an order for forfeiture of the property to the state. B, by substituting for subclause 2 the following. The forfeiture order referred to in subsection 1 shall specify A, the property to which the order applies, B, any mortgage or charge secured by or over the property, C, the property excluded from forfeiture under section 40, D, the property forfeited to the state, and E, the extent to which any property forfeited to the state is liable for areas of revenue to a local government. C, by substituting subclause 3 the following. The Attorney General shall, where a court makes an order for forfeiture under subsection 1, publish in the newspaper of wide circulation in Uganda and the gazette particulars of the property for which an order for forfeiture has been made. D, by inserting immediately after subclause 3 the following. A person who has title to any property or whom claims any interest in any property in respect of which a notice is published under subsection 3 may apply to court for release from forfeiture of any of his or her property within 30 days from the date of publication of the notice stating the particulars of his or her claim. Where the court is satisfied that the person making an application under subsection 4 has title to the property or any interest and was not a party to the commission of the specified offense or any other offense under this act, court may make an order for release of the property from the forfeiture. E, by inserting immediately after the subclause 4 the following. Where the court has made an order for forfeiture of property under this section, the minister may, in consultation with the minister responsible for finance, sell the property forfeited to the state and remit the proceedings of the sale to the National Fund for Narcotic Drug and Psychotropic Substances Control established under section 72 of this act. Justification for this is for clarity to harmonize section clause 41 and 42 to specifically require court to make a forfeiture order. 3, to make provision for the recovery of property by persons who are not concerned with or privy to the specified offense with reference to which the application of forfeiture is made in order to protect the proprietary rights of innocent persons. 4, to merge clause 37 and clause 42 since they relate to the same subject matter. I submit.
Yes, Honorable Kanya, Honorable Guzuri.
Thank you very much, Chair. Chair, I want to request the chairperson of the committee that is very important for us when we are making this law to look at other relevant acts we have in place. For example, the Public Finance Act is categorical. We forbid under that act creating any other fund. And we tried our best to make sure that all resources are consolidated to consolidated fund. Any organization is supposed to come up with a budget upon which they want to use to implement their program and request for money, and then we approve. Secondly, under the Valuation of Property Act, because we are talking about property, chairperson, this property needs to relate to the value of the proceeds of crime. And Mr. Chairperson, I really want to beseech the chairperson of Committee of Defense that property needs to be valued and related to the value of the proceeds of crime. And that clarity needs to be in the law. If you leave it ambiguous, under the Valuation of Physical Planning Act, suppose this is the land, the district council is supposed to pass the value of a property upon which, when you're handling civil and criminal matters, it will create ambiguity and conflicts. So we need to ensure that the chief government valuer really centralized evaluation of this property, and the value is standard. Number two, we need to be clear what is the value of the proceeds of crime that has been invested in this, and that needs to be guided here. But when we just say property, you leave a lot of room.
Honorable, we handled that issue yesterday. The issue of value, that was the issue of serious debate yesterday. I won't open it up here again today. We sorted. Honorable colleagues, in the public area this afternoon, we have pupils and teachers of St. Cosmas Bakijurula Primary School from Karungu, Masaka District. They are represented in Parliament by Honorable Sewungu Joseph Gonzaga and Honorable Sechin Aisha. They've come to observe proceedings of the House. Please join me in welcoming them. You can stand up. Welcome you. Thank you. Colleagues, also, we have members of the Wakiso Mira Growers and the Dealers Association Limited, an umbrella body of the Uganda Cat Mira Growers and Dealers in Uganda. They've come to observe proceedings of the House this afternoon. Please join me in welcoming them once again. Thank you. Now, it's Honorable Nandara.
Mr. Chairman, I am on the National Fund for Narcotic Drug. Mr. Chairman, this fund, if you tend to make...
Honorable, that is under clause 70. I don't want us to discuss it now.
That's true. That's why I'm here.
Mr. Chairman, Honorable, I would guide, okay? If the questions are around that, don't mind. Let us handle the clause the way it is. Then once we accept or reject the fund, we shall have a consequential amendment.
Mr. Chairman, the reason, okay, I have no objection to it. Yeah. The only problem which I wanted to put clear here is that the money which you get, if we are saying it's going to the drug account, we're making a mistake. And that's why I want to concur with Honorable Ekanya. All the monies which are got from anything in the state go to the consolidated fund. I think what we would say, I want to ask the chair to agree that the proceeds of the sale shall be deposited on the consolidated fund.
Now, colleagues, you remember under 41, which Honorable Jonathan raised. It was the original clause was giving chance to, even beyond the state, for people to go and make a claim. Now, if I make a claim because your dealings destroyed my family and I want to be compensated, but you're saying everything goes to the consolidated fund, how will I get my claim? So since we retained 41, 42 and 43 need to be retained the way they are in order to rhyme with 41. But when you go with the proposed amendment which was rejected under 41, then that's when you would be having all these amendments. Okay? So, Chairman. Thank you. I now put a question that clause 42 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 43.
I now put a question that clause 43 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 44.
Chair. Oh, I put a question that clause 44 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 45.
I put a question that clause 45. Yeah, 45.
Right, Honorable Chair, on clause 45, the reading of the text is that where a conviction for a specified offense is set aside by court on appeal, the person whose conviction is set aside may apply to court for a restoration of the forfeited property. For me, I think we are going to build up more cases in court where it is not necessary. At this stage, that appellant court can actually give an order for restoration. So why should we now create another cost imposed to go and apply, and yet you're already before court? So I wanted to make an amendment that where a conviction for a specified offense is set aside by court on appeal, the appellant court may order for restoration of the forfeited property.
Honourable Minister.
I concede to the proposal.
I
by
put
the
a question
member.
that clause 45 be amended as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 45 as amended.
I put a question that clause 45 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 46.
I put a question that clause 46 stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 47.
Chair.
Right Honorable Chair, Clause 47 deals with arrangement regarding tracing, realization, etc. of property in Uganda. Clause 47, the wisdom of the committee, they propose that be amended A, in subclause 2, by inserting immediately after the word by, the word statutorily. B, in subclause 3, by substituting for the words without reasonable delay, the words within 3 months from the date of the statutory order was made. The justification is to clarify what order the minister can make under clause 2, and 2, for clarity of provision to remove ambiguous words. I submit.
Honourable Minister.
Amendments allowed.
I put a question that clause 47 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 47 as amended.
I put a question that clause 47 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 48.
Chair. I put a question that clause 48 stands as part of the bill. Those in favor say aye, and to the contrary nay. Aye. Ayes have it.
Clause 49.
Chair.
Right Honorable Chair, Clause 49 deals with concealing or transferring proceeds of drug trafficking. Clause 49 of the bill is amended. A, by deleting the word drug where the word appears in the provision. B, in subclause 3, by deleting the word no consideration or for inadequate consideration. C, by substituting for subclause 7 the following: a person who commits an offense under this section is liable on conviction to imprisonment for a period not exceeding 20 years. Right Honorable Chair and Honorable colleagues, justification for this is 1, the deletion of the word drug is to harmonize the provision with clause 2, which defines the word trafficking and not drug trafficking, which is used in the provision. 2, the amendment to subclause 3 is intended to prohibit the dealing in tainted property rather than prohibiting undervaluation of tainted property as proposed in the provision. 3, subclause 7 is amended in order to comply with section 37 of the Interpretation Act, which requires criminal provisions to prescribe the maximum penalties that may be suffered by a person convicted of the offense. Right Honorable Chair, I submit.
Yes, Chivoga. Then Clerk.
Thank you, Chair.
And Oguzu.
That means the naming of the clause should also change because it still has the word drug.
Chair, is that okay? On that one, are you okay? Can you repeat for the Chair?
The naming of the clause, it still has proceeds of drug
The head
trafficking.
note.
So the name drug, the word drug should still be dropped from the naming of the clause.
I agree.
Thank you. Yes, Honorable Gilbert.
Thank you. Mr. Chairman, look at the person who commits an offense. Why are we providing only provision for imprisonment? Can we provide provision of payment also? Like in terms of currency? Or both? Because from here you are providing only strictly for imprisonment. Mr. Chairman, I was looking at providing provision or payment in terms of currency.
Provided it's an addition to what is already provided. The idea is not to substitute penalty for fines. Otherwise, people will take it lightly.
Honorable Guzuri.
Under clause 1, I would like us to add the word knowingly. Any person who knowingly, because for you to be guilty of any criminal offense, you must really have intent. I've seen a practice in Dubai where people, Ugandans, send things to you and you're supposed to transport them. So you may not have idea what you are carrying. And it turns out that you have carried drugs and things like that. So we should be able to hold someone who knowingly does this responsible for the penalties and fines or charges that are therein contained. Thank you. So, Chair, if you could admit that proposal.
Honorable Minister. Honorable Yume.
Mr. Chairman, I don't think there is any person who will come out and say, I knowingly transported drugs. It would be very hard to discern and prove whether he carried the drugs knowingly or not. I would think leave that to the discretion of court.
Thank you. With that, indeed, it's an implied term. So it's already, you carry drugs and you say, I didn't know. You must carry the burden. So, colleagues, and remind me, whenever we reach on any clause that has a minister, we must specify which minister. So you be alert. I put a question that clause 49 be amended as proposed. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 49 as amended.
I put a question that clause 49 as amended stands as part of the bill. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 50.
Chair.
Thank you. Right Honorable Chair, Clause 50 deals with prohibition of holding illegally acquired property. Clause 50 is substituted for the following. A person who aids in the concealment, disguise, conversion, or transfer of proceeds of crime commits an offense and is liable on conviction to imprisonment for a period not exceeding 5 years. Justification for this, honorable colleagues, is 1, clause 50 is ambiguous since it does not define what amounts to illegally acquired property. 2, the provision did not create an offense and prescribe a punishment. I submit.
Thank you. Yes, Honorable Jonathan.
Chair,
on clause 50.
Yes, on clause 50, I would move for a deletion. If you look at the amendments made by the committee in 49, it handles everything to do with the provision under clause 50, concealment and etc. So it will be a duplication, actually, from the amendment they have just made to 49.
Sure. Honorable Minister.
Deletion considered allowed.
I put a question that clause 50 be deleted as proposed. Those in favor say aye, and to the contrary, nay. The ayes have it.
Clause 51.
I put a question that clause 51 stands part of the bill. Those in favor say aye, and to the contrary, nay. The ayes have it.
Clause 52.
I put a question that clause 52 stands part of the bill. Those in favor say aye, and to the contrary, nay. Ayes have it.
Clause 53.
Chair.
Chair, clause 53 deals with rehabilitation centers. For clause 53, there is substituted the following. Treatment and rehabilitation centers. The minister may establish a facility for treatment and rehabilitation of persons with substance use disorder in accordance with Medical and Dental Practitioners Act, Cap 272. 2. Notwithstanding subsection 1, a person may establish a private facility for treatment and rehabilitation of persons with substance use disorder in accordance with the Medical and Dental Practitioners Act, Cap 272. 3. The object of the facility for treatment and rehabilitation of persons with substance use disorder shall be to provide for the care, treatment, and rehabilitation of persons with substance use disorder. Justification: 1. There is a need for the minister to establish treatment and rehabilitation centers to increase access to medical treatment and set standards by all stakeholders providing treatment and rehabilitation of narcotic drugs, psychotropic substances, and any other related substances abuse. I submit.
Thank you. Now, colleagues, if you have a copy of the bill under 52, the whole of Part 5, it's clearly provided that for interpretation purposes, the minister will be a minister responsible for health. So it's already provided for under the whole of Part 5. Chairman, Committee for Health.
Substitute clause 53 for the following: treatment and rehabilitation centers. Subclause 1, the minister responsible for health may establish, designate, or approve treatment and rehabilitation centers for the treatment and rehabilitation of persons with substance use disorder. 2, the minister responsible for health may authorize a person to establish a private treatment and rehabilitation center for the treatment and rehabilitation of persons with substance use disorder. 3, a person who wishes to establish a private treatment and rehabilitation center under subsection 2 shall make an application to the Uganda Mental Health Advisory Board established under the Mental Health Act for accreditation of the treatment and rehabilitation center. 4, a person who has received accreditation under subsection 3 shall apply to the minister for authorization to establish a private treatment and rehabilitation center. The justification is to empower the minister responsible for health to designate or appoint treatment and rehabilitation centers, as well as regulate the establishment of private and rehabilitation centers.
Yes, Honorable Songa, and then
Yeah, thank you very much.
Dr. Boka Didi.
First, we may need to get the true meaning of establish. Otherwise, it will mean the minister is going to establish a new center. But the question is, currently, where are we rehabilitating the substance abusers? Thank you.
Honorable.
To that point, I would really propose that we can identify the current or existing rehabilitation centers, give them more budget so that they can also handle substance abuse.
Can you start with that, Chairman?
Thank you very much, Mr. Chairman. I would like to recommit clause 52 interpretation of part 5.
No, recommitment is done after we have finished. I wanted you to respond to Honorable Songa. As I understand, the current rehabilitation centers are not provided for under the law. Are they?
Under the Mental Health Act, the facilities under the Mental Health Act also do treatment and rehabilitation, among other things.
Mm-hmm.
Yes.
So what Honorable Songa is saying, that we already have them. So when you talk of establishing, so should we say the ones which are already existing will be provided for under the transition clause?
Clarification.
Yes,
Chair, this is a new phenomenon that we are dealing with. The only established center that does treatment and rehabilitation, the only one, is the Butabika National Mental Referral Hospital. The only one recognized. If I may, the other centers are privately established. They are so exorbitant, they are unaffordable. They charge a lot of money that is. So what this law intends to do is to give the minister authority to establish treatment and rehabilitation centers other than the national mental referral hospital.
Yeah. Honorable, I had allowed Dr. Boka Didi.
Yeah. Thank you, Mr. Chairman. I want to start by clarifying on the difference between establishment and a licensor. Under the Mental Health Act, Butabika is a health facility. And why we say this treatment and rehabilitation is because we consider this as health facilities. The authority that licenses health facilities is the Uganda Medical and Dental Council or any other allied health facilities following laid down criteria. That clarifies the issue raised by him. The second observation I want to make is in regards to the practice of treatment and rehabilitation. There's a third component that oftentimes is neglected, which makes many of the cases of people affected by drugs relapse, and that is the social rehabilitation component. That has acceptance within the community, but also preparing them to be able to have a livelihood for them not to fall back. That should be considered within this. So instead of having treatment, I would like to propose that we have treatment, rehabilitation, and social reintegration. Thank you.
Okay. Honorable Nakato.
Thank you, Right Honorable Speaker. Right Honorable Chair. I wanted to add on that most of these rehabilitation centers, whether private or government, Butabika has two, but they are not well equipped. Because we have we have classes of these casualties. Like a student may be brought and then he can be put on treatment. Then after a while, he stays as if he's normal, and then still he takes again opium. Then at a time, you can't take such a person to Butabika or a rehabilitation center. My proposal is that these rehabilitation centers are by the names, but the equipment and the care, sometimes you only find physiotherapists, sometimes you find psychologists, but not medics. I want to submit. Thank you.
Thank you. Yes, Co-Market, and then Honorable Agnes Tucker.
Thank you, Chair. It's better that I clarify. The entire Uganda has only one rehabilitation center, which is in Butabika. Now, it's so important that we differentiate between psychiatric patients and drug addicts who are attaining treatment. It's very important. Butabika has two units. There is alcohol and drug unit in Butabika. That is not for psychiatric patients. It's only for addicts. And it can accommodate only 50 to 60 clients for the entire country. There is no any other rehabilitation center owned by government in this country. When they come with the notion of establishment, the chair correctly states that that clause mandates the Minister of Health to go region by region or in whatever place to establish new rehabilitation centers for the treatment of addicts. Currently, if you go to Masaka Regional Referral, Ogulu, what they do, Butabika, Mawaso also, they combine mentally sick patients with addicts, which is wrong. But because of inadequacy of resources and staff, that is how our country is operating. I just wanted to clarify.
Thank you, Right Honorable Chair. Right Honorable Chair, laws are made as the situations are. And currently in our country, the rate at which the youths are abusing drugs is too high. Therefore, the issue of establishing, I propose that it should stay, but rather maybe we have the minister shall establish so that we have, yes, so that the minister has the authority to, we have a way of following up on the minister that it is a must to establish the rehabilitation centers throughout the country so that we have those services easily accessed by even the most rural Ugandans. Because right now, almost every village has at least between 10 to over 30 youths
Thank you.
abusing drugs.
Now, colleagues, I'm not seeing anyone here who is against establishment. We need them. But now, do we need to say, Minister, you must? No, funds are out, Honorable Boss. If funds are out, the minister will establish.
Thank you very much, Right Honorable Chair. I think that is better drafting, that you allow some discretional powers. And that what you are falling short of saying is that as long as funds permit. And here, the law being proposed is that the minister may establish, designate, or approve. So it's not just a question of establishing, it's more wider. And when you put shall, then you're killing the intent of this law. When you put it as a mandate, we believe that the Minister of Health will be the minister who cares about Ugandans and will take her work very seriously. So the discretion will not be abused. But this is to give her the latitude, or him the latitude. Next time could be Honorable Jonathan, who is the Minister of Health. Give her or him the latitude to perform her duties. But also in drafting, it is only proper that the word may is adopted internationally.
Thank you. Honorable Taylor, you wanted to add on?
Thank you, Honorable Chair. Well, as I entirely agree with Honorable Both, may we suggest, because of the gravity of the problem, to talk about regional centers as opposed to generalizing that he may set up centers. If we refer to regionally, then we'll be able to spread them widely and then also reach out to different individuals who are having the challenge.
No, Honorable, in legislation, you don't do that, okay? In legislation, that is a policy matter now. It becomes a policy matter which depends on availability of funds and all that. I put a question that clause 53 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 53 as amended.
I put a question that clause 53 as amended be stand as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it. Now on this 53, the one for health was reinforcing the one for defense, and we agreed it will be cleaned up at the final stage. Yeah.
Clause 54.
Chair.
Right, Honorable Chair. Clause 54 deals with rehabilitation fund. Clause 54 is amended by inserting in subsection 2 the following: money provided by medical insurance. Justification: some clients under treatment and rehabilitation centers have insurance policy covering such conditions, and therefore in case of admission, the insurer shall pay that money to the rehabilitation fund to take care of the patient. I submit.
Chair, Committee on Health.
Thank you, Chair. The Committee of Health proposes a new amendment that clause 54 should be entirely deleted. The justification is that it's a policy of government through the Public Finance Management Act to restrict the establishment of funds.
Now, this addresses the concern which had been raised by Honorable Kanya earlier on, referring to the PFMI. Is it different in any way or another? If it's not different, we move. Well, so I put a question that clause 54 be deleted. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 55.
Now, Honorable colleagues, then it would have to delete clause 55, clause 56, clause 50. Yeah, those three, isn't it? Yeah, so now, colleagues, I put a question that clause 55 be deleted. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 56.
I put a question that clause 56 be deleted. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 57.
Chair. I put a question that clause 57 stands as part of the bill. Those in favor say aye, and to the contrary nay. Oh, Chair, yes, you had an issue? Okay. I didn't know you have many troops here, Chair. Yeah, sure.
Thank you, Chair. This new amendment, by substituting the committee's proposal, is a new amendment. By substituting the Rehabilitation of Narcotic Advisory Committee for the Rehabilitation of Narcotic Addicts with the following: the Uganda Mental Health Advisory Board. Mr. Chair, the Uganda Mental Health Advisory Board is established under the Mental Health Act 2018 and shall advise the minister responsible for health on matters that the minister may refer to the Uganda Mental Health Advisory Board relating to the administration of the centers and the treatment and rehabilitation of persons with substance use disorder. Justification is the Mental Health Act defines mental illness as a diagnosis of mental health conditions in terms of accepted diagnostic criteria made by a mental health practitioner or medical practitioner authorized to make such diagnosis. And one of the examples of mental health conditions includes addictive behavior due to alcohol, stroke, substance abuse, among others. Therefore, since substance use disorder is categorized as one of the conditions that fall under the Mental Health Act, then it is best if monitoring of the treatment and rehabilitation centers is given to an already existing board doing the same work as the advisory committee for the rehabilitation of addicts that the bill seeks to establish. Thank you.
Yes.
Chair, would it be improper if we added Minister of Health and Minister of Education? Because most of these substances, young people begin it at school, and some of us who are in this social sector face a big challenge. If you have the Minister of Education that is not informed, would it be a problem if we added Minister of Health and Minister of Education?
Honorable Esrim, because someone will also say add Minister for Youth, because the youth are the most affected. So that, yeah. Honorable Minister?
I agree to the proposed amendments by the
Put
chair.
a question that clause 57 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 57 as amended.
I put a question that clause 57 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 58.
Honorable Yume.
The committee proposes that clause 58 be deleted, and the justification is that the functions have been incorporated under clause 57. Thank you.
Honorable Minister.
Agreed, Right Honorable Speaker.
Honorable colleagues, I put a question that clause 58 be deleted as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 59.
Chair, Committee on Defense. Oh, you still have proposal for a new clause? Okay.
Mr. Chairman, the committee proposes insertion of a new clause immediately after clause 58 as follows: treatment, rehabilitation, and admission of persons with substance abuse disorder. Subclause 1, a medical practitioner, mental health practitioner, parent, guardian, or concerned person may refer a person with substance use disorder to a health unit or treatment and rehabilitation center for treatment, care, or rehabilitation. Subclause 2, a person with substance use disorder who has attained the apparent age of 18 years may submit voluntarily to a health unit or treatment and rehabilitation center for voluntary treatment, care, or rehabilitation in accordance with the Mental Health Act 2018.